Anna University sexual assault case. The High Court has axed the Goondas Act against that man, the man in the picture, Gnansekaran. Almost exactly a year ago, on 23rd December 2024, a 19-year-old engineering student was sexually assaulted within the Anna University campus. The perpetrator was found to be Gnansekaran, a repeat offender and history sheeter who allegedly had easy access to the campus and had not only threatened the survivor and her friend, but also recorded the assault which he used to blackmail her. The Chennai Mahila Court sentenced Gnansekaran to life imprisonment without the possibility of remission and also imposed a fine of 90,000 rupees on Gnansekaran. The known history sheeter from Kotturpuram in Chennai, he was charged under the section 63A rape, 64(1) punishment for rape, 75(1)(2) sexual harassment and 75(1)(3) which is sexual harassment under the Bharatiya Nyaya Sanhita. Now, the latest in this case is that the Madras High Court on 15th of December revoked the Goondas Act against Gnansekaran. Now, under this act, which is the Goondas Act, an individual can be detained without bail for up to 1 year. Now, for a common person, much like me who does not understand legalese, revoking the Goondas Act may come as a bit of a surprise against a man who is accused of sexually assaulting a woman and perpetrating grievous violence on her partner. But then it was revoked, ladies and gentlemen. Now, this happened when a division bench comprising Justices V. Murugan and M. Jyoti Raman were hearing a petition filed by Gnansekaran's mother Ganga Devi. During the hearing, the additional public prosecutor told the court that the Goondas Act was invoked based on the sexual assault case, the one which happened at Anna University, and charged under section 63A, and I've just read out all the sections that are applicable towards Gnansekaran. But then the bench observed that since Gnansekaran had already been convicted and sentenced in the sexual assault case, the preventive detention order could not be sustained, and there ended the matter. Let's understand from a legal eagle, from a legal expert. Rekha Agarwal, who's advocate of the Supreme Court, has joined us on this broadcast. Thank you so much, Rekha Agarwal, for sparing the time. Tell me, when we have Goondas Act, I mean, I'm sure we will put up the graphics about what Goondas Act is. It's about anyone who indulges in certain kind of activities, and it's a non-bailable offense apparently. When this man who is accused of having sexually assaulted a woman, also perpetrating violence on the partner, why is it that the court decided to revoke the Goondas Act, ma'am?
Ma'am, it's very simple, and I do understand what you said that for a common man, he's a gunda, he's a bad man, he means trouble, and therefore such a man should face the Gundas Act, which seems to be the apt label. In fact, it seems to be rather mild label for a man who has committed such heinous crimes, that too sexual crimes against such a young student, and he's been a habitual offender. But however, the court doesn't the judicial system and litigation doesn't depend on what the common man thinks. It has to go strictly according to the rule book. And the since the Gundas Act is preventive in nature, it talks about preventive detention, which means before a crime has been committed, but you sense trouble. If the police, the law enforcing agencies, they sense trouble, then they can arrest a person in advance, because such a man may do something which is wrong, which is illegal. But once the very purpose of prevention of such a crime has been defeated, it's actually been defeated, because before it could be prevented, as they say, prevention is better than cure. But here, before he could be prevented, he has committed the crime. So he's made it what is called fait accompli. So now and now that he's already been charged under various sections of the Bharatiya Nyaya Sanhita, as would be applicable in the present FIR against him, he's gone through the trial, and various sections of BNS have been invoked against him under the earlier it was the Indian Penal Code, and very strict charges have been upheld by the trial court against him, and he has been punished. The trial is over, punishment has been awarded against him. Now there's an appeal before the division bench of the Honorable High Court, and the High Court in its wisdom has rightly said that since he has already been convicted, so therefore there cannot be an order of preventive detention against him. In fact, preventive detention laws are actually absolutely abhorrent to our basic constitutional rights. Where one of the biggest rights that we have is the right to freedom. And
Right.
preventive detention laws are only, invoked in those cases where there is extreme likelihood of trouble, and to prevent such an act, as I say, prevention is better than cure. So before the man commits any such heinous act, for example, terrorist activities,
Right.
etc., so then this act is invoked. But here the man has already been convicted.
Right.
So now still continuing to apply the Gundas Act upon him and to uphold the punishment under the Gundas Act would be a travesty of justice and a contradiction in terms. When the
Haji,
man is behind bars, how can you prevent him? He's
right.
already done what he
He's,
had to
yeah,
do. So he has
absolutely
to
right.
suffer the,
Yeah,
yes.
that's common sense and legal common sense as well. But then why was it brought in front of the bench then by a prosecutor?
Because this again shows the beauty of a legal system, that yes, just because he has been convicted, and the APP, the additional public prosecutor, also has got a great responsibility to uphold in the court, and he is not only speaking for the state, but he also has to uphold the rule of justice, the rule of law. And when the public prosecutor has rightly, in fact, I think it is a beautiful admission by the APP that yes, Gundas Act should not be invoked against the
Fantastic.
charge should not be upheld against him,
All right.
because he's already behind bars. So
All
it is
right.
a contradiction in terms. It's like making a mockery. So therefore,
Okay.
the public prosecutor, in his wisdom, has conceded or rightly been
All
fair
right.
enough to the court by admitting that he should not, the Gundas Act charges should not be sustained.